Hello guys, welcome to my channel. The less is more. So today we will discuss an editorial from Indian Express, and that is about the fundamental right. Okay, we have taken the polity today. So, and it is about the privacy, and the Supreme Court upheld that the right to privacy is a fundamental right under the Article 21. Okay, right to life. So that's why the privacy becomes important in today's era, because the data is the new oil. So let's start the editorial directly. The title of the editorial is Personal is Private. After months of delay, the Union Cabinet on Wednesday approved the draft data protection bill, clearing the way for it to be introduced in Parliament in the upcoming monsoon session. This digital personal data protection bill forms an integral part of the regulatory architecture that is being ushered in by the ruling dispensation to govern India's ever expanding digital economy. While more clarity is awaited on the finer points of the bill, some modifications have been carried out in the version of the legislation that was put forth in the November last year, as reported by this newspaper. However, some of the more contentious aspects of that version have reportedly been retained. These require careful examination. Okay, some more contentious aspect has been retained. Okay, and some have been done away. Of particular concern is the sweeping exemptions afforded to the central government and its agencies. As per reports, the government will have the right to exempt any instrumentality of the state from adverse consequences, citing national security, relation with foreign governments, and maintenance of public order. Considering that the Indian state gathers vast amounts of personal data, there are legitimate concerns that such wide ranging exemption could create the space for misuse of data. Equally worrying is the discretion that the government is likely to exercise in the appointment of members to the Data Protection Board. The chief executive of the board, that will be charged with ensuring compliance dealing with grievances and disputes, will be appointed by the government. In an environment when concerns are being voiced over the independence and autonomy of institutions, this raises troubling questions over the board's degrees of freedom. Reports also suggest that a change is being made in the manner in which cross-border data flows will be dealt with. The legislation is likely to have shifted towards a blacklisting framework from a whitelisting approach. This would involve allowing data flows to all jurisdictions other than those on negative list, to whom transfer would be curtailed. However, what remains unclear is the manner in which this negative list will be created. For instance, will the choices be influenced by the prevailing geopolitical environment? And while the bill has also prescribed penalties for failing to prevent a data breach at up to 250 crore per instance, there does remain some ambiguity over the definition of per instance. Considering the dramatic expansion of the digital economy in the country, bringing in a robust data protection architecture is of critical importance. This bill needs to go through a process of extensive discussion in Parliament. The provisions need to be tightened, ambiguities removed, and discretion minimized. So, in this bill there are some ambiguities, okay, and one of the contentious issue is the government have the right to exempt anyone, okay, or any institution or the any instrumentality of the state, okay, from adverse consequences, citing what? National security, relation with foreign governments, and maintenance of public order. This is the one. Then again the discretion that the government is likely to exercise in appointment of members to the data protection board. Okay, this is the second worry. The member of the board or the chairman will be appointed by the government. So board's degrees of freedom. How much degree of freedom the board will be having? And this legislation has shifted towards what? Blacklisting framework from a whitelisting approach. So it is like to everyone, the data will be flows to everyone who are not in the blacklist, but there should be a whitelist approach, like the data would be flows to only some institution or the some individuals, like those who are in the whitelist. Okay, so it would involve what? Allowing data flows to all jurisdictions. But there is some unclarity. The manner in which the negative list will be created. Bill has also prescribed how this negative list will be created. There is ambiguity on that, and there is penalties. Okay, 250 crore per instance. But what is definition of per instance? So these four issues that are being discussed in the editorial, and that should be discussed in the parliament as well, like before amending or before passing this law or the bill. Okay, so there is a need for extensive discussion. The provision need to be tightened, and ambiguities must be removed, and discretion must be minimized. Okay, so this was for today, guys. I hope you would be understanding, and please do comment in the comment section the summary or the 5 keywords that you find in this editorial. Okay, it will be helpful for you. It will help you in again reproducing in the exam. So till then, bye bye, signing off for the day.